Um, As we've heard from previous panelists in a symposium on Crimtorts, one cannot omit a discussion of punitive damages. For punitive damages provide a direct link to the criminal law in that they are explicitly meant to serve two purposes typically associated with criminal penalties: punishment and deterrence. We've also heard about the large amount of recent Supreme Court litigation in which the court has approached punitive damages from the perspectives of both substantive and procedural due process. This activity has predictably generated much debate about the proper place and the appropriate measure of punitive damage awards in tort law. It's a rich topic for interested scholars. Our distinguished panelists today have been among those at the forefront of the effort to explain, justify, or provide models for ascertaining punitive damage awards. Our first speaker is Keith Hylton, professor of law, and Paul J. Liakos, scholar in law at Boston University School of Law. Professor Hylton received his BA magna cum laude from Harvard University, his JD from Harvard Law School, and his PhD from the Massachusetts Institute of Technology. Professor Hylton.
Okay, well, after encouraging the previous panelists to sort of go after each other, I think it's probably a bad strategy for me to talk first and let people go after me after I say what I have to say. But I guess this is just tough luck on my part. So my topic today is wealth and punitive damages. Michael Rustad brought this issue up. It's going to be, of course, going to be talking about the deterrence issue in general too, but I want to focus specifically on the wealth and punitive damages question. It's a recurring problem in the case law, and again, the question is to what extent should wealth be a factor in determining a punitive damages award? You know, given that someone has behaved in a way that merits a punitive judgment, should it matter if the defendant is a wealthy person versus a poor person? We have some discussions of this in the case law. In State Farm, we have a quote that says that the wealth of the defendant shouldn't be a matter at all, or it shouldn't lead a court to hand out a punitive award that violates constitutional rules or principles. So you could read that statement in a couple of ways. You could say, well, the court's just saying don't hand out a judgment that violates the Constitution, a punitive judgment that violates the Constitution. Or you could read the court as saying you really shouldn't pay attention to wealth in punitive damages cases. And then you have attorneys who are arguing about this issue a fair amount. Michael Rustad brought up the groups that have been involved writing amicus briefs in some of the big Supreme Court cases, and I've been hauled in to write amicus briefs on the issues of economics and damages in some of the big recent cases. And on the last one that I was involved in, the Philip Morris case, the side that was opposing me, Professors Polinsky and Chevelle, Mitch Polinsky at Stanford and Steve Chevelle at Harvard, they submitted an amicus brief that was all on wealth and punitive damages, and their argument was that on economic grounds, wealth should not be a factor in determining punitive damage awards. Turns out that issue wasn't really relevant in Philip Morris, but for some reason they decided to write on that. Maybe they were foreseeing or anticipating the next big topic of litigation, because the defendant's side lawyers who are strategizing about the issues that should be litigated have identified wealth as one of the issues that they want to litigate and try to get some rules limiting or I should say eliminating any consideration of wealth in punitive damage awards. Well, the argument in favor of taking wealth into account in punitive damage awards is a pretty intuitive argument, and it's one that everyone can state pretty quickly. The notion that if you give a punitive damages award to a super wealthy person like a Bill Gates, it would be like paying a parking ticket for most of us. And so the super wealthy would view, if you constrained punitive damage awards and you didn't take wealth into account, then the super wealthy would view those awards as like parking tickets, and they would view the accompanying violations as in the same way that we view double parking or something like that, or going too fast. And we don't want people who are in that wealth class to view the violations that are at issue in punitive damages cases in that way. So that's the simple intuitive case for taking wealth into account. On the other hand, there's a rigorous economic argument that suggests that wealth shouldn't be taken into account at all. And this is the argument that was put forth in the Polinsky and Chevelle amicus brief that I sort of wrote counter to in the Philip Morris case. And their argument is, well, if we think about the incentives to do some harmful act, someone is either getting a gain from it or avoiding a cost. The harmful act imposes a loss on someone else. And their view is, well, what we'd like to do is we'd like to have a system in which the losses that injurers impose on other people get shifted back to them, and those losses are internalized to the injurers. So they argue, well, if you think about the damages system as internalizing losses, then there's really no reason to take wealth into account, because you could imagine a system in which someone comes into court, they pay a compensatory award, say it's $100 in compensatory damages, and then they pay a punitive damages award that's designed to cover the additional social losses of their conduct, losses to other victims, losses to society in general. Well, in that case, you would determine the punitive judgment entirely by those extra losses, those additional losses imposed on society, and those losses have nothing to do with the wealth of the defendant. So that argument says you really shouldn't be taking wealth into account in punitive damages cases. There's no reason to. So that argument has been made by several people. I mentioned the Polinsky and Chevelle brief that argues that, and then there was an article by Kenneth Abraham and John Jeffries in the Journal of Legal Studies that made the same argument before the Polinsky and Chevelle brief. So what I want to do here is try to offer as much as I can intuitive and straightforward arguments about this question and deal with some simple examples. And I probably won't have time to get through everything that I've written here, but I'll see what I can get through now. Maybe I should say deliver the points that I want to get across. The first point that I want to get across is that the claim that wealth is totally irrelevant, should never be a factor in punitive damage awards, is unsupportable on economic grounds. And I should make clear that my approach here is the economic approach. I'm looking at taking what you could call a consequentialist or instrumentalist approach to damages, looking at the role of damages in controlling people's conduct. And so again, the first point is that the argument that wealth should never be a factor is unsupportable, cannot be supported on economic grounds. You can come up with examples in which wealth shouldn't play a role, but as a general proposition, wealth is a relevant factor in the determination of a punitive award. I guess the second major point I want to get across is that the difficult question is when, how, and what kind of situations should wealth be a factor? Because certainly you can come up with some examples in which wealth shouldn't be a factor, and I just gave one a few seconds ago when I talked about using punitive damages to internalize costs that are imposed on society in general. You can come up with examples in which wealth shouldn't play a role, but those are just isolated examples, and as a general rule, it's easy to come up with counterexamples in which wealth should play a role. So the interesting question is when and where, what are the factors that should be taken into account in deciding whether wealth should be part of the punitive damages calculus? And not a lot has been said about that. That's an issue that I think the literature really hasn't hasn't touched on yet. Right now you have a clash between broad views, people saying, sure, wealth ought to be part of it, and people saying, no, wealth shouldn't be a part of it. So maybe I can join these two different positions. I guess the core proposition that I'm going to offer is that wealth is going to be relevant when the key parameter of interest in determining the punitive award. And when I refer to parameter of interest, I think there are two that are really important in this area. One is the loss imposed on the victim or victims, imposed on the victim or victims, or the gain enjoyed by the defendant, his illicit gain or his profit from engaging in some wrongful conduct. So to me, the big question in determining whether wealth is relevant all hinges on whether that loss of victims or the gain to the injured, whether those things are unobservable and correlated with the defendant's wealth. If either of those parameters are unobservable and correlated with the defendant's wealth, then wealth ought to play a role in determining punitive damages, because you need to use wealth in order to figure out whether the punitive damages should be set high or low. So that's the basic argument. I'm running so low on time right now, maybe that's as far as I'll be able to get, and I'll have to sit down. I'll be forced to sit down in a few seconds. Let me give you a few examples. Michael Rustad said so many things that anticipated what I would say today that I would, after I finish talking, you'll think that I must have given him my talk or something. No, somehow he just anticipated these things magically. I'm going to consider some very simple examples. So let's take the example of the defendant or the injurer destroys the plaintiff's painstakingly developed flower garden, and he does it intentionally. Takes his sport utility vehicle and just rides over it several times. Okay, and he does it for one reason, just to harvest the spiteful pleasure of seeing that flower garden destroyed and knowing that he's hurting the victim. So that's the first example. Should if we impose a punitive damages award in that case, should it vary depending on the wealth of the injuring party? Another simple example. Let's suppose he does it by accident. He accidentally rides his sport utility vehicle over the victim's flower garden several times, but there's no intent. Should wealth matter in that case? Okay. Again, these may sound like simple examples that maybe Michael might argue that it's divorced from reality or usefulness because they're so simple. But the reason why people tend to bring up these simple examples in the literature is that they isolate the problem that you want to look at. They get you away from distracting issues. And so the nice thing about the simple examples is you can focus on a simple proposition and then worry about the complications later. What about a third hypothetical? Suppose the injurer goes over and steals the flowers, and this time he's not seeking to hurt the victim, but he just wants to take the flowers and look at them closer up, put them in pots and look at them on his porch or something. Should the wealth of the defendant matter in that case too? All right. I have two other examples. Maybe I'll stop with those examples because I can sort of start to say a little bit about the argument here. Well, again, as I said, there are two approaches to punitive damages. One is to shift the losses of others back to the injuring party. The other is to eliminate or strip any gains or profits enjoyed by the injuring party when they engage in their wrongful conduct. And so we can work through these cases. It should be clear that when you're trying to strip the gain, that wealth might come in and play a role, because sometimes the gain that the injuring party enjoys is related to his wealth. It's a function of his wealth. Okay. And in that case, when you can't observe the gain directly, then it would make sense that you'd have punitive judgments that vary according to wealth, that make the wealthier defendant pay more than the non-wealthy or poor defendant. Okay, so maybe I should go back to the examples. I know I'm running low on time, so go back to the examples. So let's take the case where, let me take the third example first as an illustration. The third example is where the injurer goes over and just takes the flowers from the victim's flower bed to look at them. Well, why is he doing that? He's doing that because he wants to see the flowers, and he could go out and buy the flowers just as well. So the gain that he gets from taking those flowers is equal to the amount the injurer is willing to pay to have those flowers in his own possession. Okay? And if you've taken Economics 101, you know already that the amount that the amount that someone is willing to pay for some ordinarily desirable item is a function of wealth. The wealthier person will pay more, and especially for something that's just a pure consumption good like flowers, something you just want to look at, doesn't have much to do with your survival. That's clearly going to be, that gain, that willingness to pay is going to be correlated with wealth. So given that we can't observe that gain at all, wealth will clearly be relevant in determining punitive awards, and you'd want to have a system in which wealthy defendants are being forced to pay more than poor defendants. Okay? We can think of variations on this. The other variation I had was where he goes over and drives over the flower bed several times, in this case, just to see that look of pain on the victim's face. What about that? Should wealth matter in that case? Well, that's actually a more difficult case because what the injurer is seeking, which is, as I put it, harvesting a spiteful pleasure, you know, we're not sure. We're not sure that that's always going to increase as the gain that he gets is always going to increase as he gets wealthier. So we don't know. We can only make some speculation. Maybe it will. Interestingly enough, Polinsky and Javel, who made the broad argument in their amicus brief in Philip Morris that wealth should never be a factor, conceded that wealth should be a factor in the case that I just mentioned, where they destroy the flower, where the injurer destroys the flower bed just for the spiteful gain. But actually, that turns out to be a more difficult case than the first case that I gave, where he takes the flowers just to look at them, where he does it just to harvest a spiteful gain, spiteful pleasure. It's not clear that the wealthy will pay more for that than the poor, and so it's not clear that we'd always want to have a wealthy person pay more in punitive damages. We probably should, as a background assumption, because we just don't know. We can't go behind the things that we can't see, can't find out. All right, I have 1 minute left. Give you another example to consider. Well, suppose the injurer goes over and steals the flowers, and this time not to look at them, but because he's got a third party out there that wants to buy the flowers. There's a third party who for some reason has figured out that for some reason those flowers are worth a lot to the third party. And the third party is going to pay, you know, some enormous amount, say $100,000 for the flowers. And he goes over and steals the flowers for that purpose. Well, and that $100,000 goes to the injuring party, the one who steals the flowers. Well, what should the punitive damages verdict be? Well, it should eliminate the gain that the injurer experienced, which is the $100,000 profit. But if you think about that, that's uncorrelated with the injurer's wealth. So in this case, you're determining the punitive damages award by an objective measure of gain, one that you can see right there in the case. So all of these examples, I'm using a bunch of simple examples to try to illustrate a point, which is, you know, if we're going to use this punitive verdict to eliminate, to strip the gain, then we have to be sensitive to the cases in which that gain is going to be a function of the defendant's wealth. Sometimes it will be, sometimes it won't. The general proposition that punitives should never be a function of wealth is, I think, totally unsupportable on economic grounds. There's just nothing to it in terms of economics. On the other hand, you have to look on a case-by-case basis and look at instances in which, as I called it, the parameter of interest in determining the punitive award is going to be a function of wealth, and then that's going to tell you whether whether the award should be increased for wealthier defendants. Okay, there's a lot I wanted to say, but I think that's all I can say in the time that I have here, and I decided to stick with the examples because the examples, I think, get across the argument better than if I'd given you broad theoretical propositions. I'll stop here.
Thank you.